Look like a couple of bandits.
So how do they know that they're? So you don't see the other people that's involved?
They see us and we see them.
Oh.
Yeah, they can see you. They can sure can. They can see and hear everything you're saying.
And this is the YouTube?
Huh?
What is it, YouTube?
ZT?
YouTube.
They use YouTube because by Kansas law, they have to have it open to the public. So they make a YouTube recording, and that's the bare minimum for keeping it.
Oh.
Yeah.
But they won't.
But I don't know what they do over in Johnson. We're not using YouTube. Looks.
You guys ready to go?
We are, Judge.
All right. Let's be on the record in two cases, those being 2019 CR 1415 and 2020 CR 182. I just wrote down Mr. Moore's last name. What is Mr. Moore's first name?
Terrence.
Terrence, that's right. I'm sorry. Both captioned State of Kansas versus Terrence Moore. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears virtually through Assistant District Attorney Adam Saul.
And Mr. Moore appears in both cases via Zoom video with counsel Mark Boswick.
All right, we are here set down in the older case on both of these cases for a plea. My understanding is the agreement is that Mr. Moore is planning on pleading guilty to count 1 in the 2019 case, that being a severity level 9 criminal threat, that the 2020 case will be dismissed with other agreements as to sentencing. Do I have that correct, Mr. Sokoloff?
Yes, Your Honor, that's the gist of it with as you referenced, sentencing being that we're agreeing to probation. If in fact he happens to fall in the B category or A category, we will be asking the court for a probation sentence regardless.
All right. So, Mr. Moore, I'm going to have to ask you some questions to take up your plea today. Now, at any time, if I ask you something that you don't understand, you need to tell me that, and we'll talk about it until we're both clear that you understand what I'm asking, okay?
Yes.
All right. And any time, if I ask you a question, you think, hey, I want to talk to Mr. Boswick before I answer that question, you just tell me that. He'll mute your microphone and you two can talk about whatever you need to, and then you just come back on and we'll take it back up, okay?
Okay.
All right, to get this all started, I need to have you sworn in. So if you'll raise your right hand, my court reporter will swear you in.
You want me to stand up?
No,
No, you don't need
that's
to.
fine.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can put your hand down.
Mr. Moore, how far did you go in school?
Graduated from high school and took up some college courses online.
All right, you read and write okay?
Didn't hear what he said.
Yeah, and you read and write, okay.
Oh, yes, sir.
All right. Now, as you sit here today, are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what you're doing today?
No, sir.
All right, you feel like your mind's clear today?
Yes, sir.
Do you know what you're charged with?
A criminal threat and perjury.
In the two cases, you're aware of all the charges, is that right?
Yes.
Okay, and you understand that you're under no obligation to change your plea from not guilty to guilty. If you wanted to maintain your plea of not guilty in both of those cases, you would have a right to a jury trial on those cases. Do you understand that?
Yes.
All right. At that trial, you'd have the assistance of Mr. Bostwick. He would be able to confront and cross-examine all of the state's witnesses. He could challenge all of their evidence. He could call any witnesses that you wanted called, and if they didn't want to come to court, he could subpoena them and make them come to court. Do you understand all that?
Yes.
If we had that trial, you would have a right to testify at that trial, but you would also have a right not to testify. And if you decided not to testify, the state couldn't use that to argue that you're guilty. Do you understand that?
Yes.
All right. And if at the end of that trial, you were found guilty, you would have a right to appeal that conviction to the appellate courts. If you didn't have the money to do that appeal, a lawyer would be appointed to do it for you. Do you understand that?
Yes.
All right. Now, if we go forward with this plea today and you end up pleading guilty to the one case and they dismiss the other, there's not going to be a jury trial in either of these matters or even a trial to the court. You understand that?
Yes.
Okay. Any questions about any of these rights that I just went over with you?
No, sir.
Okay. I'm going to share something on the screen here, and I want you to tell me if you can see this. This is a copy of the plea petition that Mr. Bostwick sent me. I'll get up to the top of it there. Do you recognize this document?
Yes.
Okay. Would you agree with me that basically it goes over the same rights that I've just went over with you?
Yes.
Okay. Now here, where it talks about the plea agreement, it says that the agreement is as follows. You're going to plead guilty to count 1 in the 2019 case. That's a criminal threat, which is a severity level 9-person felony. The state's going to dismiss the 2020 case. Both parties will recommend a departure to sentence to probation. If necessary, you agree to pay the court costs and fees, and both parties agree to recommend the middle or standard number in whatever box that you fall in as your underlying sentence. Is that your understanding of the entire plea agreement?
Yes, sir.
All right, Mr. Bostwick, is that your understanding of the entire plea agreement as well?
It is, sir. Yes.
And Mr. Sokoloff?
Yes, Your Honor.
All right. Now, Mr. Moore, has anybody promised you anything else other than that plea agreement that I just read to you today?
No, sir.
Anyone place force or threats against you to make you plead guilty today?
No, sir.
All right. Now, there's some recommendations in here that about what sentence you should get. While it's true that I'm going to listen very closely to what each lawyer recommends and what you have to say about this, I'm not party to or bound by any recommendations, and I can give you any sentence that the law allows me to. Do you understand that?
Yes.
So with that, what I have to do today is assume, just for purposes of today's hearing, that you have the very worst possible criminal history. That way I can advise you of what the maximum that anybody could possibly get for this crime is. Do you understand that?
Yes.
Okay, so the maximum that anybody could get if you had the very worst criminal history for this charge is 17 months in prison and a fine of $100,000. And that sentence would carry post-release of 12 months. Do you understand all of that?
Yes.
Okay. Mr. Moore, do you have any questions either for me or Mr. Bostwick about anything that we talked about today?
No.
All right. And finally, I guess I'll show you there before I take it down. There's a signature where it says defendant. Is that your signature, and did you place that on the document?
Yes.
Okay. All right. Mr. Bostwick, do you know any reason why your client should not plead guilty?
No.
All right. Then I will ask you, Mr. Moore, as to case number 2019cr1415, count 1, charging you with criminal threat, a severity level 9-person felony. How do you plead, guilty or not guilty?
Guilty.
All right. Now I'm going to ask Mr. Sokoloff to tell me what he thinks the state's evidence will be in this case. I want you to listen closely, because when he's done, I'm going to ask you if that's what happened, okay?
Okay.
Mr. Sokoloff.
Thank you, Your Honor. Were this case to proceed to trial, the state believes that it would present evidence to the court that would lead the court to believe that on December 18th of 2019, at the location of 3901 Rainbow Boulevard here in Kansas City, Kansas, in Wyandotte County, specifically the Kansas University Medical Center, that the defendant, Mr. Moore, did communicate threats of violence to employees there with the intent to disrupt the regular goings-on and cause fear there. He communicated with statements such as that he would be coming down to the hospital, that he would cause havoc, and that they won't see it coming. Statements to that effect did have their intended purpose and caused victims there, specifically Miss Moberg, named in the information, to have this fear of imminent harm. And again, it did cause the disruption of the regular duties of Kansas Medical Hospital there, specifically the cessation of seeing live patients for that day and the sequestration of employees there within the hospital for that afternoon, as well as additional security measures. That evidence, I should say, would be what the state would present, that again, in December of 2019 in Wyandotte County, the defendant accomplished criminal threat.
All right. Mr. Moore, is that what happened in this case?
Yes.
All right. I will find the defendant has freely, voluntarily, and intelligently entered into his plea of guilty today. He does so with full knowledge of the charges against him and the consequences of the plea. The state has provided a sufficient factual basis to which the defendant has admitted that would support the charge of criminal threat, a severity level 9 person felony, and I will find the defendant is guilty of that charge. I'm going to order a pre-sentence investigation and set sentencing pending release or receipt of that investigation. Ladies and gentlemen, I'm looking at September 25th, and I have a 9 o'clock available that day. Mr. Bostwick, are you available September 25th at 9 a.m.?
I am.
All right, we're going to do this by Zoom again unless somebody needs me not to do so. Mr. Sokoloff, will that date and time work for you as well?
Yes, Your Honor.
Okay, so I'm setting sentencing for September 25th at 9 o'clock by Zoom. I'll make the hearing invite and send it to you immediately after this. Mr. Bostwick, do you have a copy of a pre-sentence investigation request that you can email to myself? And I'll forward it on to probation so they can contact your client.
The document that I sent you, Judge, has the pre-sentence investigation request right attached to it. All filled out by me.
There it is. Okay,
There
I
it is.
see it. All right. I'll get that over to probation today. Mr. Moore, here's what's going to happen. You need to keep in touch with Mr. Bostwick so that he knows how to get a hold of you. We are going to come back on September 25th at 9 o'clock in the morning. Sometime in the next week or so, probation is going to use that information he gave them to reach out to set up an interview to do your pre-sentence investigation, okay?
Okay, thank you.
All right. As a convicted felon now, it is prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. I won't go through the whole list. We'll talk about it again at sentencing, but before you arm yourself with something like that, make sure you talk to Mr. Bostwick to make sure it wouldn't mess up a probation or add new charges, okay?
Sometimes I ride around with a set of chef knives.
Okay.
Sometimes I cook for people and they pay me cash, and that's all I usually have is a chef bag and chef knives.
Certainly chef knives are not considered part of those deadly weapons. Obviously, if they were ever used, let's say you got into an altercation and you pulled one of those out, then that may change the whole thing. But if you have some knives that are commonly used in the preparation of food, and that's why you have them, that would not be a violation of my order today, okay?
Okay.
All right. Other things for our record today, folks.
And then the other case that'll be dismissed at sentencing.
I'll dismiss it right now, actually. Thank you for reminding me that, Mr. Bostwick. Per the plea, the 2020 case is hereby dismissed.
Okay.
All right. Anything else?
No, I think we're good.
We are adjourned. Have a great day, everyone.
You too. It's a beautiful day.